Thank you much. I'm going to use a mic that's on my lapel rather than this one, and I'm going to be speaking principally from my handout, my written handout, which hopefully you all have. It reflects more accurately what I've done and what I want, and it's a good reference source for you. The handout is not a theoretical treatise on Dormant Mineral Acts, because we could spend a lot of time on that. The Dormant Mineral Act is unique. There are about 23 states that have some form of a Dormant Mineral Act. A Dormant Mineral Act really, in my opinion, is a private foreclosure. It's a private foreclosure. It's a forfeiture. It's an extraordinary act, but it has limitations on what it is and what you can do with it. It is limited. It's not a panacea. It's not quiet title, although the North Dakota Dormant Mineral Act is a two-step act. It has one procedure. The first procedure is non-judicial. I call it non-judicial. That's where by private proceedings, the surface owner can recover dormant or abandoned mineral interest. The second stage is to actually do a quiet title, and a traditional quiet title most of you have experienced or have some idea about what a quiet title is. So it's two stages, or as intellectual professors would say, it's bifurcated. I always thought that was a good word. I've been meaning to use it. Some basics, and then we'll start on my little paper. Not all dormant mineral acts are of this ilk, but the North Dakota one is only an act that only allows the surface owner to take the advantage of the act. Nobody else can. No other party in interest. No other party in partial interest. Surface owner rights, that's all it is. So it's not a panacea at all, and it doesn't substitute for some other good due diligence and other negotiations. Only the surface owner. In my paper, I discuss what it means to be a surface owner. I won't spend any time talking about that, but North Dakota, through a series of statutes, indicates that can be entities, corporations, individuals, etc. Could be estates. But it cannot be exercised by a lessee, a mineral royalty rights owner, anyone else. Let's talk about this unique thing in American law, because you need a little basis in this. American law, U.S. law, doesn't like the forfeiture of property. We're against it. You know, the law abhors forfeiture. I love all these words. I learned them. I've got to use them somewhere. Okay. Let's look at page 16, the bottom part of page 16 of my little handout. I talk a little bit about forfeiture, because you've got to keep this in mind when you're thinking about what's going on here. What's going on here, this is a special right granted by legislatures in several states. Again, we're only going to use North Dakota as our example. I practice in North Dakota and South Dakota. But it's a special right that doesn't otherwise exist in property forfeiture law. What do I mean by that? Well, let's look at the bottom of 16. American law abhors the idea of forfeitures of property. To illustrate, a brief example of the common law of abandonment is useful. The law regarding property abandonment is well represented by the Massachusetts case that I cite, which is, by the way, still good law. In the McCovey case, the court asserts that for property to be abandoned by a rightful owner, the property must not be possessed by the rightful owner, and the rightful owner must permanently intend to relinquish possession. He's gone, but he intends to relinquish possession. How are you going to prove that? Okay, this is why our garbage can be taken away and we have no recourse. Garbage is abandoned property. You don't see that in any mineral rights treatise. The problem is that intent cannot be ascertained by an unknown or long-gone interest holder. Similarly, if the interest holder is known, he may indeed disclaim an intent to abandon. The common law of abandonment does not give any regard to the lapse of time, but most abandonment statutes, most dormant recovery statutes in the U.S. give account for the lapse of time, but the general law of abandonment doesn't do that. Thus, in the United States, I'm going on my page 17, thus in the United States, the common law of abandonment is not equipped to handle a case of abandoned mineral interests. The common law of abandonment would inhibit production of resources if followed. Legislatures consequently weighed the interests of surface owners and mineral interest owners while taking into account the public interest in favor of energy development. So this has been tested. I'll talk about it in a minute, but this has been tested by a very important case. So the legislatures in these 23 or so states I'm talking about have said, well, we want to give special attention to natural resources because we want them to be developed in our state. Okay, so you have these dormant mineral acts like North Dakota's. When you're dealing with a dormant mineral act, always go back to the basics. Always go back to the basics. It's something we all forget to do. Go back to the definition of what they mean by mineral interests. Go back and look at it because it is a powerful and all-encompassing definition in terms of North Dakota's definition. But each state is different, and each state minerals mean something different. We all know that. We all know sometimes gravel is mineral, sometimes sand is mineral, sometimes it isn't. Well, these are all quite important because they could play a role in developing your lease or using your dominant rights in a lease. Let's look at my page 2. Defining a mineral interest. About in the middle of page 2, I start out and talk a little bit about this. The inherent question in defining a mineral interest, even though it is addressed in the statute, is what is a mineral? For purposes of this statute, there are 24 or 36 definitions of minerals in important federal and state legislation in each state and in the U.S. federal government. You've got to go look at each one when you're dealing with something. If you're dealing with a federal lease or an Indian lease, you've got to go look at how they determine a mineral and what they determine it to be. I continue now from my handout. For example, when a surface owner initially leases mineral rights, the parties are required to enumerate the particular minerals to be leased. I'm now here talking about North Dakota law. North Dakota law distinguishes lease transactions from conveyances and similar transactions where granting is taking place. In North Dakota law, if you have a lease, I like to say in street parlance, you damn well better define what you're talking about. In North Dakota law, if you have a conveyance, you can be very general and broad and liberal, and the courts will uphold it. Big difference. Big difference. So when you're going back and looking at these interests to determine whether they've been abandoned or not or who you've got to give notice to, go look at how they defined it. Because you've got to look at the title history to do a dormant mineral act. But again, let's just finish the definition of mineral interest first. When there is a sale or conveyance excluding a lease of the mineral interest, whether it be for royalties or mineral interest, the definition of minerals shall be construed to grant or convey, and then I have a little subparagraph, all minerals of any nature, whatever, except those minerals specifically excluded by name. If you've got a conveyance, you can be broad, and it'll be intended to cover everything except that which you exclude. With a lease, in North Dakota again, you've got to enumerate. That's what the case law says and some of the statutes in the states say. Why is this important? Well, North Dakota's look back is 20 years, and states are different, 10 years, 23 years. The look back time isn't important. You've got to memorize the time when you're doing it, but during the look back period of 20 years in North Dakota, if there's been no activity, you, as a surface owner, can exercise your rights to recover under the Dormant Mineral Act. You, as a surface owner, can recover those rights. You look back for the 20 years. If there ain't nothing happening, then you go back prior in time of that 20 years, past that 20 years, to see who had some floating rights out there, some potential claims or rights, leases, conveyances. What's phenomenal about North Dakota's act is you can take somebody that had a conveyance, even a warranty conveyance of a mineral interest. You can take that and forfeit it as a surface owner. You're foreclosing on those interests. Most of the ones that I see, for example, in North Dakota are going to be in the 50s, 60s, 70s. There's a period of time in the 80s, of course, when North Dakota was active and then had a crash. But these are the ones usually that will show up when you're doing this. Okay, obviously that's past the 20-year period, if today is what I think it is, 2014. And you're looking back there and you're gathering carefully and reviewing all of those claims or interests. And then you're going to give them notice. You're going to give them notice that you're reclaiming. You, again, the surface owner, are reclaiming. You're going to give them notice and you're going to wipe them out. Pretty powerful stuff. So you've got to know these things. North Dakota actually has a decent due process. I mean by that, it has reasonable notice requirements. Some states, Indiana for example, don't have notice requirements. It's a use it or lose it for the mineral interest claimant. North Dakota has notice requirements. I'll talk a little bit about that, but in North Dakota, of course, you have that 20-year period, and if there's been inactivity in the 20-year period, that is, if there's been no use, I'll talk about use in a minute, but if there's been no use in that 20-year period, then you will give notice to these old residual claimants, those old historical claimants. I'll call the historical claimants those that are older than 20 years for purposes of my conversation. They're historical claimants. You have to give them notice. North Dakota says you give them notice by publication and you give them notice by service by mail. I'm not going to get hyper technical here. The point is to give a big overview and give you some of my ideas on what works and doesn't work. But you give them notice by publication and you give them notice by mail. Okay. Publication goes in the county where the real property is located. Well, what good's that going to do if the claimant lives in California, Texas, Louisiana? 48% of royalty interest owners in North Dakota live out of state. So, many of these claimants are not going to be local. They're not going to be still working on a farm in whatever county, Dunn County, North Dakota. D-U-N-N. You give them notice by publishing it in the local county newspaper of Dunn County, and nobody lives in Dunn County. There's 3,000 people that live there, but in the winter there's maybe 1,000 people that live in Dunn County. And then you have to serve them by mail at their last known address, found of record. So you go back and look at a deed in the 1950s and use it, and I've done that. And that's what the law requires. 1850 Main Street, Denton, Texas. If there still is a Denton, that's a joke. There is, of course. And if there still is a Main Street, which may have changed, it probably named it after one of the politicians locally. You've got to give that, and by law, if you use the of record address in North Dakota, that's adequate. That's adequate. Regardless of how old it is. And there's case law in North Dakota and South Dakota that says that that's adequate. The North Dakota and South Dakota have kissing cousin statutes. They're very similar. So you have given notice, even though they're probably still not at 123 Main Street in Denton, Texas, because that's where they would have lived in 1951. But that's adequate notice. Now, I'm going to repeat myself a couple times for some important issues, but if there is no address of record, then you have to make reasonable inquiry under the statute. And reasonable inquiry is defined by 4, 5, 6 different steps. Reasonable inquiry is actually defined. In other words, your due diligence as a searcher or the party encouraging or telling the surface owner or representing the surface owner is defined for you in the statutes, which some people say, oh, they didn't hit everything. They named these 4 or 5 things you're supposed to do, David, but they didn't do everything. They didn't provide every possible contingency. You're right. You're absolutely right. Due process of the law is a constitutional concept that's been around since the Constitution was written, and there ain't no black letter definition of what the devil's due process means. And reasonable notice is meant to comply with the concept or principle of constitutional law called due process. And it's intentionally ambiguous because you cannot foresee every contingency. But in any event, for the last several years, North Dakota has laid out for you how you do your reasonable inquiry. It's laid out 4 or 5 things, which we'll talk about perhaps, that you do to show it. And then you keep a record of those 4 or 5 things, and if you're lucky enough to find the person when you do those things, then you've got to give them notice based upon your research, based upon your inquiry. Makes sense so far? There is a lot of argument, however, that dormant mineral statutes aren't very good. And some inestimable jurisdictions with a great deal of authority and prestige, such as Texas, don't believe in it. Texas doesn't have one, and a lot of other states don't have it. I think that by and large, having a dormant mineral statute has an advantage because at least you have a roadmap under which you can try to recover some of these old interests, give an opportunity to these antique claimants to put up or shut up, because they have the right to step forward and make claim, by the way. We'll talk about that. But I think having a roadmap is better than not having a roadmap. I think, by and large, it works better than not having it. But my experience is mostly with it, so I have a natural bias. But I see it as a better vehicle than the receivership or some other vehicles that one could use, because it's easier to get clean title. Talk about clean title for a minute, because there's some misconceptions about these dormant mineral statutes. Again, I'm speaking about North Dakota's only. You have a two-stage process in North Dakota. Remember, you have the non-judicial, what I call the non-judicial foreclosure, and then you have a quiet title action, which is an elective opportunity you can have as a surface owner after you've completed the first stage, the non-judicial stage. You got the second stage, you can do it. You don't have to do it. I will tell you, however, when you're dealing with most active producers and when you're dealing with some hot property, the producer is going to require that the surface owner go to the second stage and do the second stage. It's just going to require it. So you want to make sure, if you're involved in whatever relationship with this process going on, that first stage was done right and done complete and done accurately and done fastidiously. Because that sets the grounds for the second stage, the quiet title action. Now, quiet title actions exist in most states, of course. The Quiet Title Act is pretty uniform across the United States, and it is one vehicle through which you can determine title ownership to mineral interests, old and new. North Dakota has a general quiet title action and has since the 1890s, and also has this special quiet title action, which is a part of the Dormant Mineral Recovery Act. It's a little special because it gives a little extra bonus. It gives more rights to the surface owner and to the parties involved. What's unique about North Dakota's special quiet title action, which again is a part of the Dormant Mineral Act, is that I'm paraphrasing here, which I shouldn't do. My mother says I misquote everything. Well, I got that when I was a teenager. But anyway, in a special quiet title action under the Dormant Mineral Act, if there has been a producing lease in operation or in production at the time, the producer is immune from any liabilities if the quiet title action is reversed on appeal. That would be one advantage. So it immunizes, in effect, the producer from problems if something goes awry during the course of the quiet title action, which is an immunization that isn't found in general quiet title statutes. Well, so let's talk about this 20-year period, because that's also obviously important. The period of time in the states are different. At the end of my article, I list several of the states and talk about them. I think I talk on that on about page 25 where I go through the states. That's not my created chart. I will not take authorship for it. I received that from a bank. I won't name the bank. Oh, I don't mind naming the bank. It was Wells Fargo. They had... I don't care, really. Wells Fargo did that, so I don't know how accurate it is or how timely it is. It was done several years ago by an in-house counsel, and I thought it was just a useful little reference source. I don't want to suggest it, but it's a nice little reference source. But let's talk about the 20-year period for a minute. We won't talk about it for 20 years. The Act mandates that if a mineral interest is not used for 20 years immediately preceding the starting of your dormant mineral procedure, technically 20 years preceding your notice of first publication, you do a publication 3 times in North Dakota, 3 times, 3 consecutive weeks, you do it in the county public newspaper, et cetera, et cetera. You go back, count the time 20 years from the first pub. Okay, So the Act mandates that if a mineral interest is not used for 20 years immediately preceding the first notice of publication, then the mineral interest is deemed abandoned. Okay, that's pretty good. That's a rebuttable presumption. That means, technically, under North Dakota's Dormant Mineral Act, even though a surface owner completed the dormant mineral process, it's still possible because it's rebuttable, it's still possible that a claimant, if he has a legitimate basis, legal basis, could step forward after the act and say, hey, you didn't do it right, you didn't give me notice, I was of record, or I was found of record, or you could have found me quite easily because I moved to Minneapolis and I own the biggest bar in Minneapolis and my name's on the outside of the bar in a marquee. I want to set aside what you did in your private foreclosure. Again, I'm using the term private foreclosure because that's what I'm trying to define this dormant mineral procedure as. So that is a rebuttable presumption. If, however, you go to the second stage of the Dormant Mineral Act and do one of these special quiet title proceedings, that rebuttable presumption turns into a quieted title, which is a much higher level, much better claim of title ownership by the surface owner, and is not very easily rebuttable at all by anybody coming in later. Again, provided they were given notice of the quiet title action, which means you got to sue them. But even in a quiet title action in North Dakota, South Dakota, Montana, etc., you don't have to personally serve them if you have made due diligence. Here we got this due diligence again. You don't have to serve them. You could serve them by publication if you've shown good effort, even in a quiet title action. It's not very good practice, but sometimes you have to do it. I see all kinds of different ones. Okay, so deemed abandoned, that's rebuttable. But if you do a quiet title action, you've got a much better title. But let's go on. The principal exception to this abandonment during the 23-year period is what I call the savings event. Savings event. If you have one of these savings events within the 20-year period, you cannot achieve success in trying to do a recovery of these old interests by the surface owner. The surface owner ain't going to do it right. What are these principal savings events? I call them savings events. The statute doesn't, but I like to use words that work. And law is written by a bunch of lawyers, so it doesn't work very often. Some savings events. One would be, within the 20-year period, recording a statement of claim. You can perpetually, in North Dakota, continue your interest, even though you don't functionally use the interest, by every 20 years recording a statement of claim and a statement of claim and a statement of claim. Do a lot of people do it? No. Do a lot of people do it right? No. Can you do it? Yes. Should it be done? Yes. Do I see it done right a lot? Again, no. But that's one way of saving it. You don't have to use the interest. You don't have to produce on it. You don't have to be doing something active with it. You can just perpetuate your rights by keeping your head alive, and every 20 years, re-recording your interest, even if it all goes back to a mineral deed of 1950s, et cetera, et cetera, et cetera. That's one way. That's one savings event. Oh, well, I'm on page 4. I'm at the top full paragraph on page 4 of my article. I'm going to jump around to talk about deemed use in a minute, a bit further. Well, let's go to page 19. Let's just talk about these savings events now, because this is really exciting. I've got a little chart. It should be on the top of your page 19. I don't know if your printouts are following mine, my little binder notes here. 19. Okay, top of 19. What are these savings events? These are tolling events, you might say, if you were a technical lawyer. But a savings event will allow that claimant of whatever ilk to still keep his claim. Okay, look at the left-hand part there. Here's the traditional ones. These are by statute. These are identified by statute. These aren't just common law, case law, or just fabricated by regulation or anything. If you're producing minerals under the interest, even though you don't have something recorded in the 23 years, if you can prove that the minerals are in production, you're good as gold. Gold is a mineral, by the way. Next point. You're conducting present operations for injection, withdrawal, storage, or disposal of water, gas, or other fluid. It's kind of the same as operations under most leases, or production under most leases, but the statutes threw that in there. I think that North Dakota borrowed that from Indiana, and I don't think they don't do much stuff in Indiana. But that's kind of the same thing. We would call it in production because most contracts would include these acts as acts of production or acts of operation. Anyway, third bullet point, please. Produce solid minerals, probably a statutory redundancy. My law clerk argues this, but I don't think so because solid minerals are gold, and you produce gold differently, for example, than you do produce liquid minerals. Next bullet point. You can have a savings event by recording an interest to a subject lease, mortgage, assignment, or conveyance in the county where the interest is located. The typical conveyance or documents, or even a memorandum of lease, even an option would do it. Think of how tangential that is, but an option would do it. Options aren't used that much in the western U.S., but more in the east. Options to lease, et cetera, et cetera. Next bullet point, which is a savings event. When the mineral interest is subject to either a voluntary or mandatory pooling or unitization that is recorded in the county recorder's office in the county in which the mineral interest is located. Next point, taxes are paid on the mineral interest. That's a really broad one. I don't think they knew what they were talking about because you could be paying income taxes on it, or you could be paying severance taxes. North Dakota comes and goes sometimes with its statutes. Sometimes it taxes things, sometimes it doesn't. For 5 years it'll tax stuff, and then it'll abandon it and wait 10 and start it up again. They go through mood swings, taxation mood swings. I guess that's what Mr. Will would call them. But even paying income tax, if you could prove it back, that would be a savings event. If you could prove it back to having something to do with production or a bonus payment or something of that ilk related to the operations. Last bullet point on the savings event by use. A proper statement of claim is recorded. That will save you. A statement of claim. Nothing more, just a statement of claim, even if there ain't nothing in production. Now let's look at some other savings events on my right-hand column of that chart on the top of page 19. What is a savings event? If the surface owner fails to give publication notice or satisfy the notice requirements of the Dormant Mineral Act, well, you're still there. You're still good. Until the surface owner takes affirmative action to try to forfeit or foreclose, as I say, you're still good. You're still good. You're a claimant, even though you're not in production. The surface owner has to take some affirmative action, has to start giving that notice. That's the point of that one. Next point. The interest holder cures the failure to record a statement of claim within 60 days after first publication, et cetera, et cetera. Now, here's something quirky in the law. Once you start the publication, again, which I said you do for 3 days, 3 times, 3 consecutive weeks in the local county newspaper, really, I think this is a keep our newspapers busy law more than anything. Because these county newspapers in these small counties don't have a lot to publish. They'll even publish my editorials, which tells you something about their need for news. But you have a second grace period, so to speak. Once the first notice of publication is published, you have 60 days if you're a mineral claimant to still assert your claim. And if you do that within the 60 days, and if you follow the technical rendering and rules of the Dormant Mineral Act, and you're doing it in good faith, of course, you're going to preserve it. So you get one last bite at the apple, a 60-day bite at the apple. Now, this is very curious. Think about this. I don't want to get too logical here because this is a law. And there's no reason to get logical with the law. You just have to figure it out and abide it. You have to publish 3 times for 3 consecutive weeks. So what's that, 21 days or more? It could be more than 21 days. But the claimant has only 60 days from the first date of publication. So they might, who knows? And by the way, the mailing notice provision doesn't have any particular delineation in it in North Dakota as to when the mailing is supposed to go out. most practitioners will definitely issue it out before the date of the last publication, but that could be the 21st day. So we're reducing this period of this grace period significantly by the curiosity of the way they set up the timing under the law. But you have the final 60-day period. That's my point. Let's go down to my third bullet point on the right-hand column. Other savings event. Surface owner fails to sue in district court to quiet title. If they fail to sue, that's a way to do it if they didn't give you proper notice. Next savings event. Surface owner sues the interest holder, but the court finds in favor of the interest holder. Obviously, that would save you. You would have to defend a lawsuit in that instance, of course, unless you got the lawsuit vacated because of lack of notice or lack of service of process and the like. Last point. Surface owner engages in fraud, misrepresentation, or other misconduct, and any judgment is subsequently abandoned. Those are uses that will preserve it and not require and not put the claimant at risk of losing their rights. Well, I've talked a little bit about what the surface owner does. I've talked a little bit about use, deemed use. Again, I've emphasized that the simple recording of a statement of claim could preserve it. The recording of something reasonably non-related, like an assignment of a lease or a mortgage which referred to mineral interests, or, of course, a mineral deed, within that 20-year period, would preserve it. So you have these preserving things that will prevent somebody from foreclosing on you. How does it work? How does it work? Who does what, and what happens when somebody does something? Let's look at page 5. I got another just functional chart, which hopefully makes this a little bit understandable. Let's look at the bottom of page 5. What are the duties of the mineral interest holders? These are the claimants. I sometimes use the word claimants. The two left-hand vertical columns are the mineral interest holders and what they're supposed to do or what the consequences are. The two right-hand columns have to do with the surface owner. So I'm going to go through some situations, some scenarios, and we can figure out how this kind of works. Okay, let's look at the bottom of page 5. Top category. Duties of the mineral interest holder. First category, if using the interest, no additional action is required. Okay, cool. Result, the interest is preserved. Now let's look over at the surface owner. Surface owner action. No recourse is allowed under the act, obviously, because the guy is using it. Duties of the surface owner, none. Let's look at the second category of activity. If the mineral interest is unused, prior to the 20-year expiration, the holder of the recorder should record a statement of claim. Okay, that's how we can preserve it. What's the next category for the holder? Result of interest holder action. The filing of the statement of claim preserves the interest if the sole interest holder or done by a joint tenant. If held in common, only the filer's interest would be preserved. Again, in this category, if a claim is filed by the mineral interest holder, the surface owner can't do anything. He's got no recourse unless he wants to challenge the legitimacy of the statement of claim, which brings me to an important point. We always have the issue of potential defamation of title, which will apply to mineral interests. Defamation of title means, of course, filing a false instrument of record in which you're claiming title onto yourself or damaging somebody else's title. Do I see false claims? Yes, I do. Because a lot of this stuff is filed and done by laymen trying to be cute or smart, or done in the old days when nobody thought it was that important. Or sometimes it's done by professionals that shouldn't really be doing it because there isn't enough facts to support the claim. Well, those type of claims still could be challenged, and a statement of claim, if not based on a legitimate interest, could of course be challenged. Let's look at the third category, please. Left-hand column, duties of mineral interest holder. If unused interest and the holder fails to record a statement of timely claim, what happens? What are the results to the mineral interest holder? Let's look at the second column. The interest is extinguished unless the holder, again, within the 60-day final grace period of the surface holder's notice publication, either files a claim or files evidence of use. There is a quirky provision in North Dakota's law that says, well, file a claim or file evidence and document of use with supporting documentation, that'll be the same thing as a claim. So if you don't file those things, and if your interest is unused, and you're the interest claimant, you're cooked. What are the rights of the surface owner? Let's look over here in the right-hand column. The first notice by publication begins the 60-day final grace period in which the interest holder has to cure, the mineral interest holder has to cure the recordation failure or show some use. And what are the duties of the surface owner? Right-hand column, far right. After the expiration of any continuous 20-year period of non-use, the non-use period, the first notice of publication must, of course, be published. That starts the first step, the non-judicial forfeiture or foreclosure step, which some people are satisfied to stop there until their property becomes in the oil patch. Some people don't want to expend the money to go to the second stage, the so-called quiet title action. You find that in the peripheral areas around the Bakken, for example, in the tertiary areas around the Bakken, where southwest North Dakota would be an example where maybe they want to spend the money on the quiet title action. I think that's a mistake because I think once you've got the paperwork going and the record is fresh and clean and your research is fresh, then you want to be able to prove it up to the court. You don't want to wait 5-10 years down the road and go dig up a dusty file or retrieve your data electronically, but really not know why you didn't do that Social Security search you're supposed to do under the North Dakota's reasonable inquiry standards, et cetera, et cetera. You want to have it fresh. So I think it's a mistake if you as a surface owner are going to go to the expense of doing the first stage, the non-judicial forfeiture stage, finish it out. If you don't have the budget to do that, I don't know, you shouldn't be in the game. You should sell your interests. Let's look at the bottom category here, please, the very bottom one, which carries over onto the next page. What are the duties of the mineral interest holder in this scenario? If the interests are unused and the interest holder fails to record and fails to cure that failure after notice is given, then what is the result? Look on the next page, top of the next page. The result to the mineral interest holder is it's abandoned upon first notice of publication. What are the actions required of the surface owner? They're here. The requirement that the surface owners have standing to sue, they can also sue at this stage for quiet title. And then there's a duty. Obviously, there's a publication requirement. But the suit is optional. Again, the suit is optional. The quiet title suit is optional. Let's look at the last one of these responsibilities. Okay, the scenarios. The last one on the top of page 6. The mineral interest holder must defend a quiet title claim, or the court will enter a default judgment against the mineral interest holder, which would be the same thing as a substantive judgment against them. And the result, as regards the mineral interest holder, would be that failed to exercise its duties, and assuming a successful quiet title action, the mineral interest holder would have lost their rights. And then on the right-hand side, we talk a little bit about the action required of the surface owner and the duties of the surface owner in the event there happens to be a quiet title action. And if the surface owner is successful in the claim, the quiet title action should really be, the court will enter judgment perfecting title to the mineral surface, to the mineral interest into the surface owner. That's very interesting. And it does quite a bit. Where did all this come from? This all came, the Supreme Court of the United States has said these mineral statutes, these dormant mineral statutes are okay. We're going to support them. We think they're good. We're happy about this. Now, where does that come from? Well, there's the Texaco case was a famous case that did come out of Indiana's abandonment statute. In the Texaco case, which didn't require active notice, did not require active notice to the mineral interest holder by the surface owner. Even in that case, in 1982, the United States Supreme Court said, well, it's all laid out in the statute, and it ain't really a condemnation. There's no state action involved, so it ain't an illegal condemnation. It's kind of a private thing between the surface owner and the mineral interest owner, and it looks like there's reasonable notice because there's a publication requirement, even though there's nothing affirmative required to be given to the mineral interest claimant. We think this passes due process muster, And we, therefore, the Supreme Court speaking, we approve the Indiana statute. Since the Indiana statute was basically upheld as a legitimate method, many states, including North Dakota and South Dakota, really parroted the Indiana statute, but added additional notice requirements. So there are additional notice requirements. The Supreme Court, in its comments, said, of course, we see the purpose of these statutes because it's intending that the states are trying to advance the production of the natural resources in the state. That's a legitimate policy and police power of the state. We think these statutes make sense, even though these are quite unique statutes because they don't have all of the notice requirements of other type of forfeiture statutes in the real property law of the United States. They don't. Other forfeiture statutes have a higher standard of notice, but these don't. But again, the Supreme Court says, we're happy with what you've done. Continue to do it, and we'll support it. So it's passed fundamental muster. There have been some quirky things in it. Really, the quiet title supplemental lawsuit stuff in North Dakota has only been around since about 2009. Before that, they had to resort to the old-fashioned quiet title action, which was a little bit more cumbersome. I want to again emphasize the importance of the quiet title action for a couple of minutes. Let's look at page 10, the last full lengthy paragraph in page 10 for a minute. This is a judicial method of retrieving dormant mineral interest enumerated in the Dormant Mineral Act, that is the quiet title action. It appears that including the judicial method is a redundancy, as I said, since North Dakota already has a quiet title act. Again, the main difference between the quiet title claim brought under the Dormant Act and the quiet title brought under the general quiet title statutes is found in the wording of the Dormant Mineral Act. Under that section, where a surface owner has obtained a judgment under the Act and the producer at that point in time has an outstanding oil and gas lease, the producer is considered a bona fide purchaser and the lease remains in effect even if the judgment is later vacated for any reason. The Act appears to be concerned with fairness, and rightly so. If a judgment is entered that merges the mineral and surface owner's estate, but the judgment is later vacated because of some reversible error, it only makes sense to preserve the producer's existing lease, which is in keeping with North Dakota's pro-production policy. So there is some immunization here, and it makes some sense. The North Dakota Quiet Title Act does not expressly address this scenario. Now, it does not prevent a third party from making a claim on the surface owner. Basically, the immunization that takes place under this special quiet title action is in favor of the producer. A third party could still possibly step forward if they had grounds. Bear in mind, they've got to have legitimate grounds. You can't just be doing this willy-nilly. Let's talk a little. So we've learned that you just have to give notice to the last place of record, which may be found in a 1951 conveyance or deed. But if there isn't, and it's surprising, but I see leases and deeds that don't have proper addresses in them. I see reasonably sophisticated, this is mostly going back from the 90s backwards, but I see leases and deeds where there aren't proper address identifications in the documents. Then you'd have to step over and do some reasonable inquiry to find the name of the lessee, to find the address of the lessee in Denver or Dallas or wherever they might be. You would have to do your reasonable inquiry. What are these reasonable inquiry steps that the legislature effectuated in the statute? Because they're very unique, but they make some sense. Are they perfect? No. Are they complete? No. Do they have errors in them? Yes. Do I think that they're a roadmap? Yes. Do they offer some guidance? Yes. Is that a benefit? Yes. What are they? Let's look at page 12, please, the first full paragraph. What is this reasonable inquiry? Because we are always worried about due diligence, reasonable inquiry, etc., in the work that we do. In terms of reasonable inquiry, to locate one of these old claimants that might show up of record but do not have a address of record, here's kind of a rundown. Reasonable inquiry requires a number of steps. It is required that the owner of the surface estate or the owner's agent or attorney perform the reasonable inquiry. The surface owner must search the county records for evidence of use. Okay, that's easy enough. We've already started that process at some point. Search the county records for evidence of use. Next, search the clerk of court's records for any judgments, liens, or probate records. Okay, that's a little different agency. Then you've got to go to the clerk of court in the subject county. Some attorneys suggest that you've got to do a comprehensive statewide search of judgments against the missing parties, so to speak. I'm not sure that you need to go that far, but it's not hard to go that far with electronic record recovery systems available. You can still go statewide for judgments. Again, however, you're really looking for judgments that are liens against the subject land, you're looking for liens against the land, and you're looking for probate records in the subject county. Because if the mineral interest owner were an alien, that's a legal word that doesn't mean anything except that an out-of-state party living in Colorado, let's say, and the things going on in North Dakota, if they're out of state, North Dakota technically still requires that the mineral interests have to be probated in North Dakota. Now, do some operators accept and do some producers accept adequate due diligence and showing of affidavits of heirship and that stuff? Yes, they do. But if you look at North Dakota statutes, it still requires some type of a probate in which the mineral interest is transferred completely. So when you're doing a reasonable inquiry, you've got to look at the probate records for purposes of following the Dormant Mineral Act. Next point. Point number 3 on my paragraph on page 12. Point number 3, search the Social Security Index for the last known residence of the mineral interest owner if deceased. Now, this is an ambiguous one and presents problems. I'll come back to it in a minute, the Social Security Index. Next point, search a free public internet database to locate or identify the mineral interest owner or any heirs. There are a good number of free public interest databases that I use that do work and are reasonably accurate. The problem one is generally the Social Security Index if the party is dead. Because, of course, if you've got Bill Smith, deceased, you've got a real issue. And by the way, the Social Security Index death search application form requires that you have to identify a lot more than Bill Smith. You're supposed to say, where's their place of birth? Well, you're not going to know that. What's their Social Security number? Well, how in the devil are you going to know that? They actually require that when you do a death search. And where's their place of death? Place of birth, place of death, Social Security number. So these Social Security Index searches are problematic because the accuracy of them is something at issue, I can tell you. But these are the steps of inquiry that you take. Okay, what kind of interest can you recover? What mineral interest-wise? Can you recover royalty stuff? Can you recover mineral interest? Can you recover all kinds of stuff related to mineral interest? Yes, the definition of mineral interest is so broad, I might even have it here. Yep, I do, page 20. This is North Dakota's definition. Every state is different, and every state considers some peripheral minerals different. And keep that in mind because gravel and sand, for example, are used in production, and if they're not included, your guy might want to start using, the dominant estate producer might want to be using the gravel or sand right on the surface, on the least subject property for purposes of making roads, making cement, and so forth, may not be able to, making concrete, not cement. Okay, let's look at the top of page 20. This is North Dakota, mind you. Every jurisdiction is different. Mineral interest defined. In this chapter, this is the dormant mineral interest. Oh dear, I'm running behind. I'm going to stop right now. In this chapter, unless context or subject matter otherwise requires, a mineral interest includes any interest in oil, gas, coal, clay, gravel, uranium, and all other minerals of any kind and nature, whether created by grant, assignment, reservation, or otherwise, owned by a person other than the owner of the surface estate. You could cancel out royalty interests. Royalty interests are a hybrid in North Dakota doesn't know what to deal with them. It's kind of like, a juvenile delinquent. Do you keep them at home? Do you send them to reform school? That's the issue my parents had. But in North Dakota, royalty interests were defined in the 80s and early 90s as personal property interests. Then the case came along in the 90s, and North Dakota said, well, we think royalty interests are real estate interests. So they put them back in the real estate category. Notwithstanding the comments of my predecessor here on the podium, North Dakota arguably considers royalty interests as real estate interests, and they may or may not be required under the financing statement security agreements that he was speaking about, but I would still put them in there. But here's the point. This is a very broad definition, and this definition includes clay, gravel, uranium, oil, gas, et cetera, et cetera. So you've got a lot of stuff. You've got a lot of stuff that is a mineral interest. And you can use this really to your benefit to clean up title, to complete a development, et cetera. I think the Dormant Mineral Interest Statute is worthwhile. I think it could use some improvements, but who couldn't? And I don't know why more states don't have it, but then I don't know some of the iterations of how it would work under receivership in Mississippi or Texas and so forth. I think with that I'll end my comments because I think I've gone over time. Thank you.